Ladies and gentlemen, ladies, this is Etta Jones, and I Sorry. We're gonna be kicking this video off with some research that we're doing. This is gotta get back to the page I was on. As you can see, a lot of research. Come on now, we gotta go all the way back. Abandoned foreclosures. We're gonna cover this information here. Definitely gotta download this one. Haven't downloaded it yet. And what I'm gonna have to do is convert this to Word. Life is like a song, y'all. Life is like a song. Alright, ladies and gentlemen, the reason why we're doing this video is because we need to let some of you know what options you have out there dealing with foreclosures. Look, I've been on the net. I've been doing a lot of searching on the net, as you see, a lot of research. You can't see below this line right here, but I have at least 30 forums open. There you go. That's how you can see. Okay, that's just most of them. Okay, now what I'm gonna do is my conversion tool. Convert. She found a dream, y'all. Now, when I convert it, what I want to do is I have two different documents that I want to show you all what's going on. Okay, this is done, and get rid of you, and I can get rid of you, and it's going to open up Microsoft Word. This right here. That's what I need. This is the other thing we're going to talk. See, not to be published in official records. Okay, we're going to official reports. We're going to take care of that in a minute. Got to change the background color. Okay, see, it allows me to have this document, ladies and gentlemen, to where it's editable. Well, no, not this section. This is the section I wanted to have editable, but I can't edit it. It's pulled up as a PDF. And the only way for me to do it is to print it up, get rid of the pictures, because you see, that's what's not being done. Is the pictures is the thing that's causing it not to be able to read the letters. Okay, so eventually that's what I'll do so that I can copy and paste. There is a reason why we're doing this document. I'll show you in a minute. Matter of fact, what page was it on? And this is by the Loyola Consumer Law Review. Loyola Marymount here in California, southern Los Angeles area. Okay. You remember Hank Gathers and what was his, Bo Kimball. Yahoo. Yeah, sorry about Bo never amounting to what everybody wanted him to amount to. But Bo, alright, young man. Alright, ladies and gentlemen, ladies and gentlemen, we got to get our Atlas going. Got to get rid of this. 1 second. Uh-oh. That's it. We got to go. See, it's supposed to be continuing. And it's getting on my nerves. Bad to the bone. Okay? Because that's me. Bad. You see, I decided we were going to go to the blues era, okay? And so I chose the top 100 blues tunes from the day I was born. Sorry, had to clear something up. There you go. Telling me it's got to do 100 of them, and it didn't appreciate me having to do 100 of them. All right, ladies and gentlemen, those of you, real quick update on the birth certificate issue. Those of you who have done the birth certificates with us, we're going to be processing a document for you. That document will go ahead and help secure a better position with your status. Okay, we will file the document for you. There is no charge for it. Your signature and notary is not required. We're just going to remove you from part of the system. We will then get a copy of the letter to you, so you'll know what was sent out. Okay. However, because the information is proprietary and because this was not part of the agreement originally, we're going to redact it because we don't want you shopping our products around the internet. So again, we're going to provide you this service free of charge. It imposes on you no obligatory duty under any circumstances with any party. So it's not something that can come and bite you in the rear end later. Also, each one of you who have paid the $260, the original $260 price, not the $269 price, because remember the $269 price is just registering the birth certificate. And I forgot the other things that, registering the birth certificate. I forgot the other things that's taken care of because that's not what this video is about. Okay. And those of you who paid the $550, okay, you are included in getting your federal EIN number as a foreign corporation, done the correct way, not done the Jack Habit way where people are just doing it just to be doing it. Now, this document is talking about the foreclosure echo and abandoned foreclosures. See, this ain't supposed to be doing this. So they getting on my nerves. And the minute, no, as a matter of fact, I'm downloading all the videos anyway. I've been running a little slow because, as you see, I've been doing a lot of things on this computer. So, sorry that there's been so much going on. One less cross to bear, and he's live at the Radio City Music Hall. Now, if y'all don't know what the Radio City Music Hall is, then y'all slept on the boat. Okay, you shouldn't be asleep on no boat. You can drown. All right, here we go. The abandoned home or abandoned foreclosures. Let me let you all know what a trend this is and what's happening now. What's happening is abandoned foreclosures. Banks are walking away from what's called zombie title or limbo loans. These are all the terms used to describe the situation where a homeowner is in default, but the foreclosure does not proceed in a normal fashion to the eventual sale of the note, or the home, excuse me. The phenomenon first surfaced in the Midwestern Rust Belt state, where they don't have a lot of jobs. Anyway, Congress, at the urging of Ohio representatives, called for an investigation into the relationship between vacant properties and abandoned foreclosures. The General Accounting's Office commenced a study that was released in November 2010, and all we have to do is go down to number 20 to see what the name of that report was so that you can go look it up. GAO-11-93. Okay? There you go. That's how you find out about the report and what they found out. All right, let's continue. The study was limited in that it only examined loans owned by the larger servicers and government-sponsored entities, Fannie Mae, Freddie Mac, those type of people, Ginnie Mae, HUD, and Bank of America, Wells Fargo, those larger institutions, including Aquin. It concluded that most servicers do an equity analysis before determining whether to initiate foreclosure. When it is not economically beneficial to foreclose, the lender charges off the loan without initiating a foreclosure. Ladies and gentlemen, a charge-off means they receive tax credit. Okay? See, the accounting term charge-off means the company writes off the loan as uncollectible. This allows the bank to take a tax deduction for the loss. So you see the word deduction. Let's make sure you understand, because I've been telling you this for years, especially when you have credit card debt. Anytime they do a charge off means that they receive credits from the government. They never credit that to your account. They receive the benefit, and you do not have accurate accounting because they never charge it towards your account as a positive accounting. But I've been telling you that for years, and here you are reading it in the Cornell, Loyola, let's say Cornell, Loyola Marymount Consumer Law Review. Okay, Loyola Law School. That's who did this, and they're telling you what I've been telling you for years. That's why I'm able to get people's debt to go away, because I can prove that once it's charged off, the amount of the credit that they receive is supposed to be credited the borrower's account. So each one of you should be going into court and getting a judgment that they have done inaccurate accounting. Okay, but we're going to talk about that later, because we have a document here that's going to show you how to do a declaratory judgment. Okay, just got to find it. It's here somewhere in front of me, but I don't know where it never it is, y'all. I don't know. Oh well, let's see. This is a passport document somebody told me to look at. So, nah, we can delete, because I already have the other one. That's right there. Okay, so let's see. Power of attorney. Oh God. Not gonna find it now, ladies and gentlemen. I thought I would, but it's declaratory judgment. It shows you exactly how to proceed to get one of those. Well, anyway, let's finish this. Some lenders reported initiating a foreclosure but abandoning it before the property was brought to final foreclosure sale, as illustrated in the GAO, Government Accounting Office, chart. Reproduced below, properties evaluated in the study were significantly more likely to be abandoned by the homeowner if the loan was charged off after the foreclosure was initiated than if the charge-off occurred before the foreclosure program began. See, charge-off, charge-off, charge-off. They receive credits. That's why you are going to do your discovery. You can do a pre-lawsuit discovery, demanding any and all financials regarding the property. Why? Because if they receive credits, okay, look, 19,000 properties occupied, 8,000 additional properties are vacant. That's where you have and these properties are not up for sale. Okay? And eventually what we're going to do is if people are walking away from their property and they don't want it to go to the bank, then we're going to provide a program for those people to assign the interest over to us. And we'll come in and we'll take control of the property. And we'll give the bank a run for their money. We'll make sure it's not easy on them to take the property. All right. This is just one document. Let me show you guys the top portion of this document so you can see where it came from. So you can see what you need to... This is the exact title. So if you put Foreclosure Echo, see that right there? Let's go back here. Foreclosure Echo. Foreclosure Echo. How abandoned foreclosures. There it is right there. Scholarship law. Okay? Scholarship law. Now, let's do something, because we told you guys about this gentleman. What was his name, y'all? I don't remember the guy's name because we just talked about him last week. As a matter of fact, because I have to keep going back and forth to this particular page, we'll just do this. This is the YouTube, so that it will continue. And then we just go back here. All right, the gentleman who wrote this, his name is in one of these. And these are all PDFs, okay? But the gentleman who wrote this, what we have learned from mortgage foreclosure process about transferring. Okay, with respects to the titles on which the mortgage is based, mortgagee policy, what have the courts said? What have the courts said about the produce the note? You guys have heard people say they must have the note. Well, let's find out if that's true. I don't know why my internet speed is going so slow. Apparently everybody wakes up on a Sunday morning and they connect to the internet. So it's actually draining the internet speed here. in Los Angeles. I'm so sorry that that's happening. So let me show you the article for which this video started so that you all will know. I think it's this one. Nope, that's that one. This one. It says not to be published on official reports. Ladies and gentlemen, this is a California case. Okay, I don't care about this part right here. This is a JP Morgan case. Okay? Let's find out what's going on with this Court of Appeals, State of California, 6th Appellate District case. What was decided? Well, let's find out what's going on with this case. The plaintiff, the Milex, okay, he and his wife, at the 21 Road Trust, and the 21 Road Trust, they put their property in a trust, filed a preparatory lending and wrongful foreclosure lawsuit after Milek defaulted on her mortgage payment and faced a non-judicial foreclosure. The trial court sustained respondents' demur without leave to amend. Yeah, they dismissed the case. These individuals appealed. The plaintiff argued that they have stated a cause of action challenging the authority of JP Morgan Chase Bank, Chase, and California Reconveyance Company, which I don't like them. I know they're in the valley. Don't like them at all. I think they're in Woodland Hills, but I'm not sure. Anyway, to initiate and proceed with the foreclosure because neither entity owned Malek's loan, because Chase and CRW or CRC, California Reconveyance Company Corporation, have not produced a promissory note and a recorded assignment of Milek's loan. They argue that they have stated causes of actions for fraud and wrongful disclosure based on alleged forgery, and they make a general request this court review their 12 claims in light of the 2012 Homeowners Bill of Rights. Ladies and gentlemen, you need to go over the 2012 Homeowner Bill of Rights. That's the first thing. Second, you need to know why, when, and how you can bring a challenge to the assignment. There are only several reasons why you can bring a challenge to the assignment. For the reasons stated below, we conclude that the trial court did err and that the plaintiff have not shown on appeal that the first amended complaint may be further amended to state any cause of action challenging the loan initiation and the authority to proceed with the foreclosure. We will therefore affirm the judgment. Factual background. Our background summary is drawn from the first amended complaint and incorporates exhibits and judicially noticed exhibits supported the respondent's demur. Malex purchased a residential property, blah, 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 and they mentioned WAMU and all that. So we don't want to go here, okay? Oh, by the way, notice of default, an election to sell under deed of trust. That's what you get in California. An election to sell. They're using an election. They don't have the right to use that election. The first election is mortgage default insurance because you get a notice of default. So the first election, they cannot do the election to sell under deed of trust. It is the deed of trust that they're going by. It's not the note. Many people are still getting confused by that, and I don't understand it. I don't understand it. Or as MC Light would say, I cram to understand. I don't know why YouTube do this. Gotta keep clicking on it. Matter of fact, you know what? We just gonna leave that screen up there. Okay? Yeah, it's a connection problem, y'all. And alright, well, we're downloading all that. Let's go to something simple. Maybe YouTube don't like the blues. Okay. You guys know me. I just said maybe YouTube don't like the blues, so I'm just typing in don't like, and I'm gonna see what's gonna pull up under don't like. I don't like dirty. I don't like Chef Kef. Don't know him. Don't care. It says dirty. I don't want to listen to nothing dirty. Okay, I guess he's the only one who sang "Don't Like." Don't like. Yep, he's the only one, y'all. We're not gonna do metal right now. Sorry, can't handle metal right now. I used to listen to Metallica, so I can't handle metal right now. Uh, guess what? Don't like didn't really pull up nothing. So I tell you what. Why don't we do that, ladies and gentlemen? See, I tell you what. I think many of you should try this. It does work, but I'm looking for a song. I'm not Young Thug. I'll tell you what. Okay, so I'm not looking for Mr. Hill. He and I we had our moments, but nah. Only Young Thug? Come on now. God, I'm gonna have to do better. Okay, I don't want to listen to the Spice Girls. Sorry. Don't want to listen to the Spice Girls. So, and this is gonna be the last one. Hmm. I should have put the last one because I said this is gonna be the last one. You know what? I don't know who Keith Gates is or Kevin Gates is. Uh, don't know if he's clean or dirty, but we're gonna listen just to the beginning to see what
Viagra
we
single
get.
packs.
Gotta get rid of that commercial. Sorry, can't stand them. Y'all know me, can't stand
Coffee
them.
Mate helps you stir up a rich, creamy flavor. It can inspire you.
And don't need to listen to it. Two phones. La Familia. Oh, so he's Hispanic. Interesting. Let's see what he's got to say. Nah, cause we both know where he about to go. Y'all know where he about to go. I know where he about to go. So we ain't gonna go there. Okay? Ah, I'm so
Guys,
sorry. I tried. Whoa, I'm sorry. There is somebody that I will play. Cause I ain't
guys,
heard this young
wanna
lady in a long time.
Kevin Gates, I'm
No,
everybody's
not
sworn
that
favorite.
one.
People tend to feel like Michael Jackson.
Come on now. Kevin Gates. Oh, come on. Every time I click on her, stop. Sweet Love, Anita Baker. Okay? We
guys,
gonna do Anita because that's my girl.
guys. Want to save
That's my
50% on a
girl,
year-long
Anita.
supply of
Come on,
Viagra
two,
CBD at
one,
theviagra.com or
zero,
text.
launch. Sweet Love. Sorry, we gotta go back to 1983, 1984. Anita Baker. And we got the best of Anita Baker. And if y'all don't remember my girl Anita, then y'all don't exist. Sorry. Figment of imaginations. Alright, let's get back to our conversation. Sorry about the delay. Sorry about the intermission. Getting back to all of you. You don't have to do a lot of research. Like this case right here. This case is not really talking about much other than the individuals challenging the assignment. This is not the case that we're going to focus on, okay? Although I copied the case because it came up under that law that I mentioned to you, the one that I highlighted, okay? But I'm not focused on that law right now. I'm focused on the second case. Let's see. That's number 7, so that means the second case is summation 13, 14. Okay, plaintiff did not seek leave to amend in the trial court, nor did they ask this court for leave to amend or otherwise show in what manner they could amend their complaint and how the amendment would change the legal effect of the pleading. Accordingly, the trial court did not err in sustaining the demurrer without leave to amend. Okay, and do you notice how stupid that is? Okay, they did that on purpose. That's California. Alright, now why did I show you that case? Because in there it's going to show you the law. It's going to show you all the mistakes the individual didn't do. Ladies and gentlemen, the plaintiff did not seek leave to amend. Even when the court Accordingly, the trial court did not err in sustaining the demurrer without leave to amend, because they should have put in a motion to amend. The moment they put in a motion to demur, they should have put in a motion to amend, and they should have corrected all the points that the demur highlighted, so that if they want to put in another motion to demur, which is a motion to dismiss, all they do is put in a motion, leave to amend, and correct those issues. There you go. That's how you take care of that. Again, you look at the mistake somebody else made ahead of you, and you correct it. And you just use their stupid language. By the way, they should have appealed it to the Ninth Circuit Court of Appeal, but they're not going to. Okay, memorandum in order. Okay, this is the plaintiffs, the Rosses. Okay, they brought an action against the defendant Deutsche Bank. Now, this is the case, the primary case for which I'm doing this video. And they said Deutsche Bank, they were seeking an injunction and declaratory relief in order to prevent the foreclosure sale of their residence, the subject property, in Newton, Massachusetts. After removing the action from state court, the Deutsche Bank moved to dismiss pursuant to Federal Rules of Civil Procedure 12.1 to be for lack of subject matter jurisdiction, and Federal Rules of Civil Procedure and failure to state a claim by which relief may be granted. Ladies and gentlemen, remember, it was Deutsche Bank who had the matter removed to federal district court from state court, and so they argued that the federal district court lacked subject matter jurisdiction and Federal Rules of Civil Procedure. Okay, they bring it to federal court, and then now they say the federal court lacked jurisdiction. Okay, it's a little trick that they play. But what you all don't know, and what the Rosses didn't know, but they understand, is that once you bring it to federal court, the state rules apply. And the federal rules apply so as to the point that you bring up a federal issue. Now, the Rosses originally filed a suit in the Massachusetts Superior Court, sitting in and for the county of Middlesex. Okay, Middlesex. What's that, right in the middle? Oh God. Enjoining Deutsche Bank from conducting a foreclosure sale on their subject property. Notice of removal. Then they filed granted preliminary injunction. You see, the Superior Court granted a preliminary injunction, which is why they did the notice of removal. So then they did an amended notice of removal. Okay, Deutsche Bank removed the case to United States District Court for the District of Massachusetts. The Rosses should have did a notice to remain. Notice of removal. Deutsche Bank moved to dismiss the Rosses' complaint, and the Rosses opposed the motion on April 20th, 2012. Motion to dismiss plus complaint EFC, electronic communications through the court system. Alright, let's continue. See, on June 6, 2012, the court heard oral argument on the motion to dismiss and ordered both parties to submit supplemental briefs addressing the bankruptcy of the original lenders. Bankruptcy of the original lender. June 6, in accordance, the court ordered the Rosses and Deutsche Bank to file supplemental memorandums on June 6, 2012. It tells you that they did. Here are the alleged facts. This is what you all need to know. We're not worried about the bankruptcy of the bank. Well, some of you might be, and I would suggest you go over this section, because even though they're going to talk mostly about Massachusetts law, the one thing that you guys don't know, I think we're okay. Yeah, what we're going to do is we're going to bring Anita down this way. In my ear, she alright. Alright, ladies and gentlemen, so that all of you know, this is what's going on in this whole little system. What you're doing is you're looking through these documents, looking for statements made by the court that will benefit you, and you copy and you paste. Okay, we're not worried about the bankruptcy. Okay, so that's not applying to us. It may apply to some of you, so you'll have to go through and pull out what applies to you. Okay, what I'm looking for is something in particular this court said, not the post. We're looking not even for federal jurisdiction. Standard of review. Ladies and gentlemen, all the courts are administrative. okay? Each one of the courts are administrative. All of the appeals courts, they are review courts only. They can only go by what's in the record because all they're doing is reviewing. They don't have any other authority. They're only there to review. There is no constitutional amendment which gives them reviewing statutes, reviewing status, reviewing standards. Nothing. They're operating off of this. And let's see if I can find it because I do know that I do have it pulled up, but I don't know where it would be. Anita. Not there. That's bankruptcy. That's that one. That's not it. That's not it either. That's definitely not it. Nope. Not it. Nope. Not it. Not it. Not it. This is my song, y'all. Doom, 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 doom. My song. We go a long way back. We go further back than Brownstone. Uh-oh. I don't have it. I thought I pulled it up. I thought I had it pulled up, ladies and gentlemen. I thought I had it pulled up. Don't have it. Don't want to do that. Don't want to shut that one down. All right, let's do. Now I can't think of what it's called. Ladies and gentlemen, I can't think of administrative jurisdiction. That's what I'm looking for. Administrative jurisdiction. This is very important that all of you understand administrative jurisdiction. It is 100%, 1000%, 185 quadzillionth % necessary that you understand administrative jurisdiction. And yes, my internet today, it's definitely got to be in part to this. Sorry, remember you saw me over 100 of these. Okay, there is a lot of downloading going on right now. Alright, administrative jurisdiction is defined by law as activity of governmental administrative agencies and their officials in solving individual administrative cases and applying for corresponding legal sanctions by administrative procedures. All the courts are administrative. All your government entities are administrative. The Social Security Administration, the Obama administration, the Padilla administration, all administrative. So that means that they are all going by administrative law. Thus, they have administrative jurisdiction. So under administrative jurisdiction, the appeals court and the Supreme Court only stand as reviewing courts. So let's make sure of this. When presented with a motion to dismiss a claim under both federal rules of civil procedure, a district court, absent good reason to do otherwise, should ordinarily decide the Rule 12b-1 motion first. Okay? If, however, Rule 12b-1 motion is premised on a challenge to procedural standing, the motion is properly reviewed under 12.1b-6. Okay, because the capacity of Massachusetts mortgager to challenge the validity of the assignment to which he is not a party presents a question of procedural standing, the court will consider the present motion under Rule 12b-6. Now, guess what? They are reviewing the case. They're not ruling whether or not the judgment of the court violated your rights. No, they have very strict standards that they must follow under administrative law. Now, what they say here is that you can only challenge an assignment under certain grounds. They even give you the legal framework. Okay, Power Cell, and they give you case law. Ladies and gentlemen, this is where you come in handy. This is where you copy case law, but that's only for Massachusetts. Look, ladies and gentlemen, they're following the Administrative Procedures Act. And since they're all administrative, or pay attention, do you see this right here? Effective June 22nd, 2012, a mortgagee, meaning you, seeking to conduct a mortgagee, you're the mortgager. Mortgagee, the bank, seeking to conduct a foreclosure sale in Massachusetts must hold both the note and the mortgage. That's not just in Massachusetts, that's everywhere. They have to have the promissory note. And this is the individual that they're citing. Remember, I just took you there. This is the case law. Okay? Describing the golden rule of mortgage foreclosure under the Uniform Commercial Code as prohibiting foreclosure unless the creditor possesses the properly negotiated original promissory note. This is what they've decided. So this article by this gentleman who says that he has successfully done this and has put the article on the internet, let's go there, right here. This is how we started this. See, that's that law. This is his article. This is book. This is where the court is copying from. Douglas Wiley. Remember I told you guys about him? This is his blogspot.com. And they're quoting this individual who went to Massachusetts. This is the actual law showing about producing the note. All of you get to do this. You must ask them to produce the note. There are several other things you must do when you go to court. So we're going to spend the next 5 minutes talking about this because you need to know what you need to do. Okay? I got a call, I got to return to a person who just called me, and then I got 2 people whose bankruptcies I'm helping with that I got to give them a call and speak with them. Okay? Douglas Wiley. He is a law professor, gay rights advocate, and a bunch of other things. He's even a husband, father, cat owner, storyteller, whatever. Okay? Anyway, this professor put together this article, and there are comments and case law, and he says he will continue to update this article. All you guys have to do is go here. Wait, how do we get there, Mr. Jones? Mr. Eeon? How do we get there? You just say. He says anything he puts in red. My internet is moving slow, y'all. No, whoa. Body and Soul, y'all. Anita Baker. I love this song, by the way. And in my car, with my stereo system in my car, let's just say everybody else loves this song too, because they got to hear it all the time. This is my girl. She's got bass in that song. This is the section that he updates continually. So this is what you're looking for, and then you want to look up the codes and the laws that he has here, because this is where you're going to get your information to do your lawsuits, the same as I'm going to be doing mine. And got a lot of work to do, guys. Alright, I can't keep this video going because I got a lot of work to do. But what you're going to type in, just type in Douglas Wiley, mortgage foreclosures, and you'll pull up this section right here. This is his blog spot, and that's where he's updating that information. And it is updated as of 2016. Okay, it's not just 2013. Okay, the correct citation for the printed version, see, he went and updated it. As subsequent developments occur, I will add them in red. I didn't read that here. I read that in the article. I've only read the beginning of it. I still got to get through and read it. But as I told you, we were only going to go about 5 more minutes. We're going to let Whitney Houston, I'm not Whitney Houston. Sorry, Whitney. Sorry, Anita. We're going to let Anita take us out here. Sorry, that's my girl. Alright, ladies and gentlemen, thank you for taking a listen, and hopefully this information has proved helpful to you. Okay? Why? Because many of you are going through foreclosure. Many of you knew about Produce the Note. Now we're giving you case law on Produce the Note. Goodbye.